Internet, smartphones, computers, gadgets. These are very commonplace nowadays, but believe it or not, there was a time when we had landlines without internet, button phones without internet, and desktop computers with slow and expensive dial-up connections. We had to go outside to play with our friends. No distractions, no sensory overload. Life was beautiful. Until one day, it started happening. The internet went from 3GP to Edge, then to 3G, and then 4G, and 5G, and the phone started losing buttons and became touchscreens. We stopped using analog cameras that had film, and now we have smartphones that can record videos in 4K 120 frames per second, which is good, but at what cost? Our young men have become oversaturated with pictures that people used to get at Playboy, but now it's free. Our screen time has increased so much that it's affecting our mental health. Cybercrime is on the rise. We have Coco Melon and Baby Shark. Total nightmare. These days, it's very easy to generate electronic documents. We used to get bank account statements physically by joining very long queues in the bank, but now we can generate them from our bank apps in our phones in seconds. In all of these, the law has to be dynamic to keep up with these changes in technology, and that's where the Evidence Act comes in. Prior to the Evidence Act 2011, the Evidence Act had no clear provision stating what electronically generated evidence meant. In the case of FRN and Fani Kayode, the courts had used a combined reading of the definition section and section talking about secondary evidence of a banker's book seen in the old Evidence Act to get out of that fix. In that definition section, documents included computerized statements of account, and that solved the particular problem before the courts, but it couldn't apply to other forms of electronically generated documents. Luckily for us, Evidence Act 2011 fixes that issue, as it applies to all forms of computer-generated evidence, not just computerized statements of account. So what is computer-generated evidence anyway? It's simply evidence generated from a computer. What is a computer? You may be tempted to limit it to this cute desktop you're looking at right now, but if we dive into the definition section of the Act, section 258, it gives a very broad definition, stating that a computer means any device used for storing and processing information. So by this definition, a smartphone is a computer, a CCTV is a computer, an audio recorder is a computer. As long as it can store and process information, any evidence obtained from it is considered to be computer generated. Now it would be tempting to stop here, but I am not lazy. We still have to classify what is being generated into one of the three means of proof, so that it can be properly tendered in court. For those who don't know, the three means of proof are oral evidence, real evidence, and documentary evidence. Now we know that computer generated evidence is not oral evidence, because the computer isn't a witness testifying in court. It's not real evidence because the content of the computer generated evidence is what is in question, not the tangible document itself or the physical form that it's stored in. So this means that it can only be, let's say it together, documentary evidence. We can corroborate this with the definition section, by the way. It says that a document includes any device by means of which information is recorded, stored, or retrievable, including computer outputs. Now that we've figured out what type of evidence it is and properly classified it, the next question is, how do we properly tender computer-generated documents in court? Well, first off, it depends on the matter brought before the court. Is it civil or is it criminal in nature? If it's civil, then we have to make reference to the case of Okonji and Unjonkama. In that case, it states the criteria that the document must have if the courts are going to rely on it, which are 1. The document must be pleaded. In general, evidence isn't meant to be specifically pleaded, but in this case, it's one of the exceptions, because if you don't plead it, you're going to take the other party by surprise, and anything that will take the other party by surprise has to be pleaded specifically. You don't have to expressly state the document in the pleadings. Merely stating the facts that infers the existence of such documents is enough. 2. It must be relevant to the fact in issue. No matter how incriminating that nude picture is, if you bring it to a case involving land dispute, it's irrelevant to the fact in issue, and the court won't rely on it. 3. And lastly, the document must be in admissible form prescribed by the Evidence Act. For example, if it's a copy of a public document, it has to be a certified true copy of that document. But what about criminal cases? Okonji and Njonkama is a civil case, so I'm not sure that it may apply directly to criminal cases. For one thing, there are no pleadings in criminal cases, just the prosecution proving what is contained in the charges beyond reasonable doubt, so one of the criteria is already squashed. Secondly, when it comes to relevancy and admissibility, Section 4 to Section 13 of the Evidence Act 2011 covers that already, so at least we have that. Lastly, the document being in admissible form is covered by Section 84 of the Evidence Act. So as we can see, it's possible to reference this case in criminal litigation, but to be on the safe side, always clarify that it's a civil case, and always back it up with relevant sections of the Evidence Act, okay? Now how do we apply this? Firstly, we have to make sure that it's relevant to the fact in issue. If it isn't, delete it. Secondly, we have to make sure that we reference the document in our pleadings. So if we're representing the claimant, we're making reference to it in our statement of claim. If we're representing the defendant, then it's going to be in our statement of defense. If we don't do this, then we can't tender it in court, no matter how relevant it may be. Lastly, and this is the juicy part, we have to make sure that it's in admissible form prescribed by the Act. This is where Section 84 of the Evidence Act comes into play. It's extremely detailed and it will blow your mind. Like really, it will confuse you the first time you attempt to read it. For the sake of this video, I'll be focusing on the three main subsections. Subsections 1, 2, and 4. Now I'll briefly touch on 3 and 5, but those ones are pretty much self-explanatory when you've understood the main 3. Oh sorry, did I say this video? I mean the next video that's coming after this. Honestly, we wanted it to be this video, but our animator has gone to chop rice. So while we wait for him to finish, please stick around. Don't worry, we'll wrap everything up in part 2. See you soon!